going on? How's everyone doing?
Shout out to everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. I've got a sovereign citizen adjacent. At least that's what I like to call them. I did ask you guys to find a better name for this, and the best name that was in the comments was a soft sit. And I like that one. So I'm gonna start calling these soft sits. And the reason I call them this is that they're using the sovereign citizen ideology where they find obscure lines in debt collecting, uh, and they argue them even though they're wrong. So they go into court thinking they're right. They have 3 or 4 points they want to make, and none of them work. But the internet says they work, so they try them. So that's why I originally called them sovereign citizen adjacent. So soft sit, I've got a soft sit for you. Uh, yeah, even her name. Just look at what she put her name in Zoom. When I saw this, I'm like, oh yeah, this is definitely a soft sit. Soft sit. I gotta say that more clearly. You know what? I'm rambling. Let's just get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
So just stand by, Mr. All right, this is case number 23-1659-92. This is LBB Funding LLC versus Jennifer Moore. The matter is before the court, set on for a motion hearing. Counsel, your appearance regarding this matter, please, sir.
Thank you, Judge. May it please court, I am attorney Richard Bruson, and my bond number is 35222, and I am the attorney for the plaintiff.
All right, it appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right, and do I have Jennifer Moore on the Zoom?
Yes, good morning, Your Honor.
All right, thank you, Ms. Moore. Good morning to you, ma'am. All right, and it appears that the plaintiff is moving. It's right there. Yeah, well, no, I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Now, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVMV Funding when I checked my credit score. And that's how they were able to reach out to me. They were sending information to a different address. And according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting any mail and so on. So, and I reached out to the creditor, and they said that they gave my account to Midland. I have since resolved the issue with Midland, and it is paid. I then reached out to LV. They failed to give me all my information document needed, and now we're here. So I apologize for not appearing in court when I was going through my difficult times in life, but I am here now.
All right, thank you, ma'am. Mr. Rusin.
All right, let's break that down real quick. She said a lot of things, and some of the things she said does have merit. The verification or the validation, the validation of debt, that's a thing. And that's a thing that a creditor has to do. We let's see, I was just on a stream with Team Skeptic, I don't know, a week or two ago, and he was breaking down how he's putting a video together. I think it's about LVNV funding, who kind of just skips the whole validation process. Verification, validation, whichever one it is. It does matter because words are important, but I can't remember which one it is. What else was I going to say? Oh, and when if if you reach out to Midland after Midland sold it to LVNV, yeah, it's going to say it's been paid because LVNV bought it. That's how that works. So, anyways, we're gonna hear from the attorney. This attorney's he's good and bad at the same time because he gets angry real easily. I don't remember if he gets angry in this case, but he gets very frustrated very fast. I've watched this guy a lot. He's in a lot of courts for LVNV. Okay, let's go.
Response, I do see the response.
I'm not sure how to respond to a lot of that stuff, Judge. I can tell you that I have been retained as the lawyer for LVNV funding since November of 2023. I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the register of action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024. December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so the case continued. I can see that she filed an objection to the wage garnishment in this matter back in December of 24. And then the matter was argued on January 8th, Judge, on your record. She told you at that time, to my appearance attorney, that according to her argument that, quote, the matter that's before Your Honor was with Midland funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
This case was argued. I'm not done, madam. The case was continued to present. And so here we are now with good.
Mr. Rosen, I'm stopping you. I'm stopping you because your device is breaking up, and that's what the defendant was saying, is that she's not able to hear you. It was going real smooth there until about that last minute, and something went miserably bad, and so you're going in and out. You indicated the last thing that was clearly heard was that you prepared to offer a satisfaction of judgment. Instead, only about $89 or so was owed.
Exactly. Yeah, that's right.
After that, we weren't able to hear you very clearly.
Okay, so Judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment, well, I'm prepared now, to file a satisfaction of judgment because it's all paid. I have no idea what the defendant is otherwise arguing about, but on that I rest.
Well, for the rest of your honor.
Excuse me. Let me ask you, Mr. Rosen, obviously, there's something about Midland here. Have you seen anything that shows a debt satisfaction regarding any claim, any indebtedness with Midland?
Yes, that's what you need to do today.
Yeah, but I'm saying, have you seen anything along those lines?
This case is never with Midland Funding. I don't represent Midland Funding.
Okay, well, but you understand my question, right? Have you seen anything from Midland as a part of your file or anything that shows that this debt is satisfied?
Well, I'm going to satisfy it now, but if she's saying that she paid this bill through Midland Funding, this case is never with Midland Funding. This is more or less a first assignment from Credit One Bank to LBNB Funding, and that's it. This is not a case that went passed around the room like last year's potato chips. It's a one-time assignment from Credit One Bank to Midland to LBNB Funding. Midland Funding is not involved in this, and I do not represent Midland Funding in my office. On that, I rest.
All right, thank you, Council Pam. I'm back to you, Ms. Moore.
May I?
Yeah.
Thank you, Your Honor. And I agree with you. I also reached out to the original creditors. That's why we're here now, Mr. Rosen, because I did reach out to—
That's Rusin, ma'am. Rusin.
Oh, many apologies, Mr. Rusin, Attorney Rusin. I reached out to the original creditors, and they stated that my account was given to Midland, and that's where my account's set. Now, however you guys transact the assignments on collectors end, that's not my specialty. That's not my profession. However, that debt was, and as of this day, my checks are not getting garnished, so it's paid in full. There is no remaining of $89 because it has already been taken out. And moving forward, for the record, Your Honor, if they can just, what I've been requesting and asking is a debt of validation. I'm asking for the payment history. I am asking for a signed copy of the signature with the contract of my signature. I'm asking if there was any insurance claim. These are my rights to ask. You guys, LVNV, should provide me this information. Now, the debt has been paid, but for the record, Your Honor, for my records, may I have this information?
All right, thank you, ma'am. The central issue addressed by the motion in this matter is a motion to try to set aside a judgment that was entered by default in this matter. There would have to be a showing of good cause and a meritorious defense. And I've read the motion, I've listened to the arguments. I don't see a showing of any meritorious defense to the claim. Moreover, obviously, sickness would constitute some basis for showing of good cause, but you have to have both items, good cause and a meritorious defense. The whole notion of backtracking in this case prior to the entry of the judgment and demanding documentation of the debt and so on and so forth, none of that is relevant to the motion to set aside the default judgment. It's just the default judgment, you have to address the issue of whether or not there's a meritorious defense and affidavit to support that. And there simply isn't. And for that reason, after further reviewing this matter, for that reason, I don't see a basis for setting the judgment aside in this matter. It does appear that the defendant is entitled to a satisfaction in this matter, and that should be forthcoming from the plaintiff. If it's not, then the defendant may present to the court an application for satisfaction. I saw that there was something presented with the motion, but that was not in the form that is required post satisfaction of the judgment. That was a form addressing the satisfaction of a judgment in relationship to Midland, and Midland is not the plaintiff before this court. So that's my determination. The motion is denied. Again, it seems that this is at the end of the road, and I look forward to receiving a satisfaction judgment to close this out. I do wish both sides well. Good day to you.
All right, that's it. All of this for $89. This attorney is being paid more than this right now than this. How much is left on this debt? Not saying that they don't have the right to collect it. It just seems like a big waste of time, in my opinion. But they're here on motions from the respondent, I guess you would call her. Not from the LV&V funding. All right, that's it. She her motion was denied. She owes $89. Just pay the $89 and be done with it. You don't want to go back to court. And something tells me that she's gonna keep fighting this. She does not want to pay the $89. Ah, all right. Hopefully you guys enjoyed the video. Please hit that like button if you did. I would appreciate it. Until next time, bye.
Thank you, Judge. I